Okay, so video one for today, and I have written myself a script. So if it looks like I'm reading a script, it's because I'm reading a script. I actually wrote out this so that we could stay on task. I know I've done videos before on fraud on the court and what it means, but I want to continue to do that because fraud on the court, while it is a very specific type of case, once you understand how the case itself works, the complaint works, then it's a lot easier than it sounds like it is. So this video is fraud on the court. It's the full explanation, and I include in this the required jurisdictional statements. Number one, what fraud on the court really means. Fraud on the court isn't just lying in a case. It's when someone who holds power inside the judicial system, be it judge, be it CPS, be it clerk of court, be it attorneys, etc., commits an act that breaks the court itself, okay? It's the kind of misconduct that stops the judicial machine from functioning the way it's supposed to, in regard primarily, as you know, to our right to due process. An officer of the court has to be responsible for the fraud, and it has to properly cause the case to not work. This officer of the court has to cause the case to not work as the judicial machinery should. Number two, materiality. The fraud has to matter. The fraud has to be material. So I released information the other day on the difference between material and immaterial. Material fact, material evidence, etc. The fraud itself that is done to you has to be material. That means it wasn't a small mistake or an oversight. Whatever the fraud was had to have been serious enough to absolutely change the outcome of the case. Materiality is the dividing line between human error and intentional corruption. Something is material if it affects the outcome of the case, serious enough to influence a decision. Number three, intent. That's the major portion here that we are going after. This fraud cannot be proven unless you can prove intent. It cannot be an accident. Fraud on the court requires intentional deception. The person that submitted whatever information they submitted, so for example, in the case of like these social workers that like to submit all of these updates on how the mother is not making progress toward her goal, blah, blah, blah. If she knows that those things are not true, aka you have evidence, which is considered material evidence, by the way, to prove that you had accomplished everything she asked you to accomplish, or he, whoever the social worker was, that is what we're talking about here. The person must have known the information that they said to the judge to influence the case was false, and they must have wanted the judge to rely and then adjudicate based on what they lied about. Material evidence and material facts. The fraud must involve material evidence, documents, testimony, or facts that were important enough to prove or disprove at a trial. Courts don't care about irrelevant mistakes. They care about lies that were intentional and deceitful and changed the entire outcome. Okay. The but-for test. So, when we are in front of this federal judge, this is the test that this federal judge that we're going to is gonna do. It's called the but-for, like as in BUT-FOR test. Okay. The judge asks one question: would the outcome have been different but for the fraud? So that's where we win each of these cases when we properly write out our complaint. If the answer is yes, and in 99% of cases it's always yes, then the fraud altered the judicial result and qualifies as fraud on the court. Real world impact. Custody support CPS in family court material fraud often leads to wrongful custody decisions, inflated child support orders, or child support orders that should not have been entered in at all because the removal of your children was illegal in the first place. Or, CPS involvement, things that you're asked to do, etc., like all the parenting classes and whatnot. All those things that harmed you because of the material fraud. All of the things that you had to do that you wouldn't have had to do unless the fraud had been present. If the fraud causes these outcomes, it means it meets the federal definition for the fraud on the court. For example, if the fraud meant your abuser was given custody and you're paying child support because of that material fact of fraud on the court, okay? So, in many cases with domestic violence victims, that's how it goes. Or if the perjured, false things that were said about you by CPS workers, let's say if you're a dad, because there's two sides of this, and you were called an abuser, right, so that they could conveniently remove you out of the picture, and then you have to pay child support, and it was all procured by fraud, right? So anyway, that real world impact, you have to be able to show the federal judge, and in your case you can, and it's easy to do. I'm just saying it has to be clearly stated in our fraud complaint. So, attorneys cannot present false material facts. That's a little known thing, okay? Like, people assume that attorneys just lie, right? Nope. That's it. That's part of this issue. That's part of what absolutely caused this huge issue of fraud in these county and state courts. Attorneys have a duty of candor to the tribunal. If they knowingly present false material facts, they commit fraud on the court. So, this is going to apply. Attorneys are strictly prohibited from knowingly presenting false material facts by way of the rules of civil procedure. Okay, but here's the thing. You got to remember, a lot of times these judges are bar licensed, right? So, in addition to that, we have district attorneys, we have county attorneys, CPS has attorneys that are present in these things. It's also dealing with our counsel as well and our opposing counsel. So at the same time, this same attorneys cannot present false material facts. In your case, your attorney cannot collude with the other side, with CPS or whatever it is. That is absolutely illegal. They are not allowed to not present evidence. They are not allowed to. It's not just a matter of ineffective counsel if they're actually colluding with the other parts of the fraud on the court, the state actors involved in it. So you got to keep that in mind. In fraud on the court, there has to be clear and convincing evidence. Fraud on the court is not suspicion. It's not speculation, right? Actual proof of intentional deceit, and we each have it, but I just want to point that out, that the clear and convincing evidence is the material facts, the material evidence that we looked for after we created our timeline. So anyway, examples of actionable fraud. So, in our cases, as the material facts, the core pieces of evidence, etc., the core facts, in our complaint, some classic examples of what we need to be placing in these fraud on the court complaints as the core material: fabricated allegations against us of child abuse, dependency, and neglect. Forged drug tests happens all the time, okay? Intentional concealment of material facts. So, for example, they TPR'd me, but I can show you how I did the parenting classes. I went through all the assessments that they asked, etc. And when you can prove that they TPR'd you, okay, but that you did everything they asked you to do, then that is intentional fraud because they misrepresented to change the outcome of the case. If the judge had known that you had completed everything in your case plan, etc., in the case of CPS, okay, then the judge would have ruled in your favor to not terminate your rights. That is why this stuff is so important. Anyway, the three elements of intentional fraud. Courts look for these three elements: actual knowledge. These state actors, even if there's only one, it's still fraud on the court. So even if it's just a social worker, it's still fraud on the court, okay? They have to know the information that they submitted was false, okay? And that's easy to prove, all right? Calculated purpose. They wanted the judge to rely on the lie, aka You can tell, based on the evidence you have to support that, the fraud itself, that the agenda of whoever this was and that colluded against you, that the only thing that mattered to them was whether or not they got what they wanted out of what they did. And active concealment, they took steps to hide the truth. So active concealment looks like they did not allow you to present exculpatory evidence that would have cleared you. They did not allow you to present, oh yeah, I did all these assessments, completed my case plan. They did not allow you to present whatever it is. That is active concealment. If they did not present to the judge, yes, Your Honor, I am aware that this mother or this father or whoever completed their case plan on this date, blah, blah, blah. That's fraud when they don't do that, okay? All right. So the remedy for this, all right, when fraud on the court is proven, the remedy is severe, okay? Federal courts are not having any part right now of all of this bullcrap. There's a case everybody needs to look up right now. It's called the Chevron deference, I think it's called. But anyway, I'll do a video on that later. But that is, these courts are fed up with taking up for the judicial immunity that these judges in these county courts should not have based on the fraudulent actions that they're doing to people. Anyway, so when fraud on the court is proven, the remedy is severe. The court may vacate, meaning void the judgment, impose sanctions, or order corrective proceedings. The court can vacate or void the original judgment and issue punitive sanctions, okay? That's what we're going for in this fraud project. We want criminal sanctions. So for every single bar licensed attorney, CPS worker, especially the ones that aren't even licensed social workers, judges, all of these people are criminals. You understand they're criminals because you understand the effects of their behavior on your life, right? And so we're going to ask for criminal sanctions against each of these people in our cases. That is where we're going to find the accountability we need. Just saying. Now, adding the federal required jurisdiction statements for your case. So, there are certain things that we have to clearly state in each one of our complaints. Plaintiff does not ask this court to overturn or reverse any judgment. If your complaint does not clearly contain that statement, the federal judge is going to kick out your case, okay? In fraud on the court actions, this statement is essential because we are not asking the federal court to act as an appellate court. We are addressing extrinsic fraud, which is why we can't take it, by the way, to, and let me explain that real quick. We can't take our cases to appellate court because appellate court, once again, can only rule on what's already in that case, the original case. You cannot add any extra context, etc., evidence. They have to look at what's already on that record and adjudicated, okay? So they don't have the ability to alter that. Because there is extrinsic evidence, aka evidence that will prove the context was actually fraud, that is outside of what's already been presented. That's why it can't be addressed in the appellate courts. That's why it has to go to the federal courts. And I also am really thinking we should all file parallel state court motions, but we'll go there later. So we are asking the federal court to address extrinsic fraud, which the federal courts are permitted to hear, okay? The plaintiff does not ask this court to overturn, reverse, modify, or review any state court judgment. The plaintiff seeks relief solely for extrinsic fraud that corrupted the judicial process itself. That statement you need to write down. That statement needs to be at least 3 times somewhere in your federal complaint, okay? Because when the federal judge looks at it, that's what he's going to be looking for. All remedies outside federal court have been exhausted. So you must show that you have tried every available remedy before coming to federal court. And you can do that in several different ways. In your case, you're going to literally state it. The plaintiff has taken every available step to report this misconduct or this fraud or whatever outside of federal court, including administrative complaints, agency complaints, judicial conduct filings, etc. Just, list out, obviously, in that sentence, all to no avail. That's what you need to write at the end of it, is all to no avail, okay? So, that means part of your material evidence for this case is going to be every ombudsman report, every complaint that you filed against the judge or attorney. If you need help with those complaints, hit me or Adam up. Me and Adam will teach you how to get your bar complaint in, how to get your judicial conduct complaint in. Most of us have already done that, obviously. So I want a record of every single place that you filed a complaint, and I want that to be included in your evidence exhibits. That is part of your core material evidence in this case, because once again, we have to show the federal court that the reason they have no choice but to find in the case, on the complaint, is because you already took every avenue and nothing helped. But anyway, I can't push this one home enough. Jurisdiction is proper because extrinsic fraud removes the Rooker-Feldman bar. Rooker-Feldman doctrine, which we talked about before, does not apply when the injury was caused by extrinsic fraud, not by the state judgment itself. I want you to really get this through your head, because there's going to come a moment where we're standing in federal court in front of the federal judge. I can guarantee these other people are going to have attorneys, and most of us are going to be pro se, right? So you have to be able to verbally say, Your Honor, the Rooker-Feldman doctrine in this case does not bar this case from being heard, right? You have to be able to give, and so anyway, this is the spoken version of what that would sound like, and this is what you should write down as well multiple times inside your complaint. It should say, jurisdiction is proper because the injury the plaintiff wants looked at arises from extrinsic fraud committed by officers of the court, not from the state court judgment itself. Ties directly into what we said earlier. Under controlling precedent, okay, extrinsic fraud is an independent federal question and is not barred by Rooker-Feldman doctrine. So you literally included the way I just said it in your complaint. Abstention doctrines do not apply. You must state that doctrines like Younger, Pullman, or Burford do not block the case. So, in this case, you would say, no abstention doctrine applies. You need to write this in your federal complaint. The plaintiff does not seek to interfere with ongoing proceedings, does not challenge state policy, and does not request federal oversight of domestic relations matters. The claim is limited to fraud on the court, which federal courts have the authority to address. That needs to be stuck somewhere in your complaint, okay? Federal court has the inherent power to remedy fraud on the court. This ties all of the jurisdictional statements together. So, when you've written these jurisdictional parts of it in your complaint, the very last thing that it should say is, this court, meaning the federal court, retains inherent authority to remedy fraud on the court, to protect the integrity of the judicial process, and to vacate judgments obtained through intentional material deception by officers of the court. That right there, when we get to this point, when we have our cases in front of these judges, I'm just going to tell it to you like this. Part of the reason that we need to do what we're doing with this fraud project is because if you look just at your damages section, okay, which is going to include a list of all the harm that was done to each of us, okay? When you look at our damages section, then we understand that this has to stop. Part of the fraud project at this point is going to be getting this evidence in front of the federal judges so that they can no longer deny the need, and I mean the need, to intervene in the county courts. Okay? So anyway, anybody who has any questions, I'm going to post this video in the group, obviously, and either on the video itself through YouTube or on Facebook in the group. If you have a question, you are more than welcome to message, or you are more than welcome to leave a comment. And anyway, I hope everybody has a good day.